Just before we move to your appointment to being the judge of the Court of Appeal, I just wanted to ask you, what is the case that you're proudest of?
A case called Ex Parte Black re Moroney, which is reported in 83 Weekly Notes, I think. Paddy Black was an Irishman who jumped ship in 1947 and married, had children, and then I think it was probably 1962, might have been 63, left Australia, and when he came back, he was refused entry as a prohibited immigrant, and he was put out in Long Bay Jail to be deported. Kevin Murray was briefed for him, and he got me to come in, and the case went for a pretty long time. It was in front of Justice McHugh, Mr. Justice McHugh. I think it may have gone 20 days or longer, and we were against Doug McGregor, who was appearing for the Commonwealth, and Michael Hilsham, who was the junior and who was later Chief Judge in Equity. Anyway, after a few days, Murray thought I should run it because it was mainly legal arguments. But I ran the argument that the Commonwealth had no power to deport black under the legislation because black had become absorbed into the Australian community, and the Commonwealth had, relying on ex parte Walsh and Johnson, which Dr. Everett had succeeded in back in the 1920s, the Commonwealth had no power to deport him. And I had another problem. The question was, well, assuming that was right, has he abandoned his membership of the Australian community? And Justice McHugh held that he hadn't. So it was a great victory, and habeas corpus went, and Paddy Black went about his business, and for years afterwards, if he saw me around the environs of Phillip Street, he'd run up and shake me by the hand, thank me for that. So that case could never occur anymore because the 1958 Migration Act provided that unless you had an entry visa, you were a prohibited immigrant, and black was under the 1901 Act or 1903 Act or whatever it was the year, and there was no such provision, so the argument that he became absorbed into the community prevailed. So, yeah, that's a case. Another thing about it, for some reason, the Council of Civil Liberties had been asked to finance the blacks' case, running the case, and they wouldn't do it. So the solicitor and Murray and I, in effect, just did it on spec, really. So.
Did you do many cases like that on spec?
I did stacks of them. Every common law case was a case on spec, almost without exception. There was nothing said, but if you lost the case, you just didn't send in a bill. It was as simple as that. So that was it. And I think most of the New South Wales bar that appeared on the plaintiff side in personal injuries were in the same situation generally. One thing I'll say in favour of Clive Everett's seniors, favour is this. I was his junior in a case called Rigby against Associated Newspapers, and there was a trial and a verdict for Rigby. The Court of Appeal set it aside. There was a second trial, and by that stage there must have been 5 or 6 weeks of time taken in those various cases, and the defendant made a very substantial offer to settle the matter, which I thought was quite reasonable myself. But Everett said no. No, he said I can get more. I worked out what the costs were. He said no, I can get more for this man, and he went on and fought it, and that's turned out to be the case. But it would have been very easy for him to say, well, let's accept this offer. It'll cover my fees for 6 weeks, plus there'll be some money there for the plaintiff as well. But he wouldn't. He thought the plaintiff was worth more than what he would have got out of that settlement. So, that's a tribute to him, I think. And it wasn't an offer that could be rejected out of hand. It was, it might have been at the low end of the scale of the range, but it was still a reasonable offer that could easily have been accepted.